All right, everybody. Good afternoon. Thank you so much for joining. This is Vorys Seder P's webinar regarding HB 352, the Employment Law Uniformity Act. I'm Chaz Billington. With me today is Dan Clark. The inauguration got you Lady Gaga and J-Lo, but you get Chaz and Dan. It's a slightly different skill set, but arguably the same amount of firepower. With that said, let's get going. We're going to talk about HB 352 today, a big-time change in employment law in Ohio. It's styled the Employment Law Uniformity Act. It's a terrible, unpronounceable acronym, nowhere near as nifty as the ones that come out of the U.S. Congress, like COBRA, which is the best-named act of all time. The Uniformity Act is a long time coming, and we're going to go through a little bit of the history and do some other things there, but without any real hyperbole, it will transform a lot of Ohio workplace discrimination law and really to the employer's benefit. It is really an employer-friendly law. And if you nerd out on employment law, you know that over the last couple of decades, there's really not been a substantive or huge sea change in Ohio employment law, and that's why this is a long time coming and a very big deal. You get a few cases here or there that may make incremental changes in the way that Ohio's employment laws work. But if you work in Ohio, if you're a multi-state employer who's got operations in Ohio, you particularly know that Ohio's workplace discrimination laws are a bit of a mess. They're all over the place. Until now, they've been very pro-employee. And it's not something you would typically associate with Ohio. You might associate that with California, but not necessarily Ohio. And I want to make sure I preface the fact that I had some people commenting on LinkedIn and things like that when we were promoting this, that I'm not saying employee rights are a bad thing by any stretch of the imagination. But in Ohio, up until this point, we were pretty heavily slanted pro-employee, even in a lot of ways, like I said, more than a California or some of these other more progressive states. So much so that an employee, U.S. Chamber of Commerce survey that Dan and I will talk about ranked Ohio as the 15th worst legal climate for conducting business. So certainly there's a lot of room for change. At the outset, we have the nation's longest statute of limitations, 6 years, which is crazy. The better part of a decade to bring a claim makes for a lot of issues. We have so many different ways to bring age discrimination claims, a perplexing amount that is confusing to both sides of the V, for employers and for plaintiffs. Those age discrimination statutes all had different remedies and statute of limitations. We also have supervisor liability, which is baffling to people who aren't operating in the minority of states where that's the case. And so all that's about to change. We're going to talk today about a few things. First, we're going to go through the Uniformity Act's history, its goals, its rationale, its proponents, its opponents. We're going to talk about a summary of its provisions and sort of how it impacts you day to day in your workplace. And then we're going to take a little stab at the end on retroactivity. So stay tuned, buckle up, get your lunches ready. You can ask questions throughout. We ask that you put them in the Q&A. Dan and I will try to get to them. And if we can't, there's too many, or if there's just stuff that needs a more substantive answer, we may reach out individually after. So put them in the Q&A. And for those of you who are going to ask or are going to put in the Q&A, we will circulate the slides. We will circulate the slides later. We do that for one very important reason. So you will pay attention to us as we present the slides and give you the information you need to know. After this, Dan's going to do a short series of TikTok videos where he's dancing to Pour Some Sugar on Me. He's going to talk about the law in kind of a fun way. So keep an eye out for those. Without further ado, let's get moving. Dan?
Thanks, Chaz. The TikTok video will be a bonus feature for everybody that hangs on at the end and registers Absolutely. For that. Certainly this bill that is coming into effect here in April. It was introduced in October of 2019, but candidly, this is something that is decades in the making. Chaz and I both, kind of cut our teeth as employment lawyers here in Ohio, and had to learn a statutory scheme that is really, disjointed and not in line with what we're seeing in other states, and certainly not in line with the way that the federal employment statutes apply. Most of our work as employment litigators candidly is in federal courts and with federal causes of action, and state law claims are often secondary to that, but the scheme that Ohio had in place was sorely in need of some updating. And this act in new law is certainly an effort to do that. So we've got the two sponsors, Representative Cross and Senator Lang, most recently pushed this through. It was signed by Governor DeWine. And the interesting thing, for those of you who are wondering, is this employer or employee friendly? The support for this bill was really pretty bipartisan. It passed the House ultimately 57-38. And the Senate 31-1, only one dissenting vote in the Ohio Senate. The Ohio Civil Rights Commission, which advocates on behalf of workers subject to discrimination, offered testimony before the General Assembly in support of the legislation, particularly the bolstering of the administrative exhaustion requirements, which essentially send more of these discrimination claims to the Civil Rights Commission for initial review and potentially adjudication. This is signed in January, coming into effect here April 15. So these changes are coming very soon. Overall, the goals were to bring about a little more uniformity and fairness and in Ohio's employment discrimination statutes. These statutes had been written over years and modified over the years, and when you have different sets of authors, and the authors are all different committees, you end up with a final product that looks like it was written a bunch of different times by a bunch of different people, because it was, and so it didn't always line up. So some of the highlights on the new law: it's going to give our employees time to file administrative claims with the House Civil Rights Commission, although also requiring them to do so. It's going to, as Chaz mentioned, reduce the statute of limitations, which we'll talk about in a moment, and prevent some of that simultaneous situations where you've got an employer facing a charge of discrimination and a lawsuit at the same time. It's going to address some of the harassment, defenses available in harassment claims, as well as amending the definition of employer to eliminate supervisor liability in most contexts. The one thing, as we advise clients, they want certainty, right? You don't want to call and get a I don't know, or it could be this, it could be that kind of answer from your lawyer. And these changes are going to bring a little bit more certainty for employers. When does this claim have to be filed by? And when are we going to know that we don't have to deal with the situation anymore? How long do I have to maintain these records? We're going to get some clarity and more uniformity. There was certainly a goal was to bring Ohio more into parity with the federal law. I will say this is certainly a big step in that direction, but there are still, as we'll talk about in a few moments, there are some distinctions that will remain between Ohio's law and federal law. Most typically, Title VII, the Americans with Disabilities Act, those are going to maintain they're going to have separate processes, which are closer now to Ohio's, but still distinct. Hopefully, the worst thing you hear is after finding out that you've got a claim or a lawsuit to deal with, you don't want to hear you've got another one to deal with simultaneously. So you're going to have one charge and then one lawsuit, not two at the same time. Hopefully, we're going to have an opportunity to take a look at the impact of these statute of limitations and what that means for records retention. And the costs that retaining those records over a 6-year period entail. And as Chaz mentioned, the goal here was to improve the climate in Ohio, as a place to do business, both making it, bringing that predictability and certainty that businesses need, particularly multi-state employers who are looking to do business in multiple jurisdictions. As a state, you don't necessarily want to be an outlier where it's harder to come and operate there because you have to do everything a little differently.
All right, let's talk a little bit about the proponents and opponents of this law. So if you look at the list here, you'll find some notable and probably folks you'd expect to see on the proponent list, right? But there's a couple of different call outs here. I mean, some of the big manufacturers, some of the big associations, the grocers, the Ohio Manufacturers Associations are on here. And, obviously you would expect to see them on there. SHRM's also on here. The Society for Human Resources Management also heavily lobbied in favor of this, just helping the gatekeeping function of HR folks, helping their day-to-day lives, helping the way that they operate business to provide some clarity there, like Dan talked about, specifically for multi-state employers. This is a huge win for multi-state employers. What's notable on here, and Dan alluded to this earlier, is the OCRC, the Ohio Civil Rights Commission. And I dug into a little bit about what they were saying. Why is it that they would be supportive of this, specifically because arguably it's going to increase their caseload. And what they really said at bottom is that, look, requiring complainants to exhaust to first file with the OCRC gives the parties the option to engage in the OCRC's free alternative dispute resolution programs. And that is the cost-effective way of disposing of these claims. At the same time, while the parties get one crack at potentially learning more about the case and potentially even disposing of it in a really cost-effective way, if it doesn't work out, at the same time, you still can go file your lawsuit afterwards. So the OCRC really viewed it as a real true win-win. And, and that's particularly true for clients across the spectrum. But, look, not every business operating in Ohio is a huge multinational company who can withstand a costly lawsuit. And this gives businesses a really quick, cost-effective way to dispose of and resolve of claims prior to a lawsuit. If you've been through the OCRC process, and we'll talk about it a bit later, you know that it's way more cost-effective than litigation. I say that knowing what drives the cost of litigation, and it's the lawyers, right? And it's a necessary evil. But cases get into court and they can languish for a really long time. And if you've been through the OCRC process or the EEOC process, you get a couple stabs at potentially settling the claim. And you can do that even internally a lot of times. So I think that's a particularly big win. It was a big driver for the OCRC. The OCRC, though, did take time to note before the Ohio legislature that it is operating under a budget deficit and absolutely will need more people to deal with what is probably going to be a big influx of cases. One of the other things the OCRC was really keyed in on was this data, was the data component of it. And really what the OCRC was saying is, look, as the law currently stands, there's no real data collection mechanism. We don't really track the cases as they go through the courts of common pleas. We don't track that data on a statewide level. And this type of change in the law requiring administrative exhaustion is really going to allow the OCRC to dig into the data, get the number and the nature of the cases filed that are moving to the state of Ohio to better serve litigants and complainants who feel they are subject to discrimination, and it can guide future legislation or future changes at the OCRC. So they viewed that as a big component of why they thought this was a win as well. And I don't want to be remiss and give short shrift to the opponents. The only opponent that was on record was the Ohio Alliance to End Sexual Violence, and their chief opposition came from not really the whole overall bill, really the statute of limitations component of it, moving that from 6 to 2 years, as we'll talk about. And their real chief issue was that survivors may not fully have time to process and make decisions about workplace sexual harassment claims in 2 years, just because of everything that goes with those claims. They are necessarily a little more emotional, a little more physiological. And so that was their chief complaint. I think ultimately the legislature decided that 2 years, is ample amount of time, especially with the notices being provided. And that, those concerns, while valid, were still not enough to stop the legislation. Notably, as you go through and you look at the committee minutes and you look at the activity of the law at the Ohio General Assembly, you notice that there's an absence of the plaintiff's bar. The trial lawyers, none of that's in there. And we think that's kind of interesting. I mean, undoubtedly, we at least have some indication they played a role behind the scenes. We know they've been very heavily active in prior versions of this bill and attempts to change Ohio law. Here, though, you don't see that same presence. It does certainly change the playing field. Like we talked before, it tends to lean a little bit more towards parity now between employers and employees. And interestingly enough, as Dan and I were talking about, why wouldn't the plaintiffs bar be out, campaigning against this? Why wouldn't they be in the committees? And ultimately, we came to the decision that I don't know this is necessarily even a bad thing for plaintiffs' attorneys. I mean, throughout the course of my practice and Dan's as well, I mean, it's rare to see a claim that's, more than 4 years old. I personally have never litigated a 5 or a 6-year-old claim. Dan will talk more about why it's hard to do that and why it's a bad idea, both for plaintiffs and defendants. But I certainly haven't seen that. And my guess is that not a lot of plaintiffs' attorneys are bringing those older cases. And arguably as well, when we talk a little bit about how the age discrimination framework has changed, it was a mess for both sides. And if anything, my guess is it probably favors plaintiffs' attorneys only because Dan and I both talked in depth about how many what we would call quick, cheap wins we've gotten because somebody didn't understand the age discrimination statutory framework. Either they missed the statute of limitations, they didn't realize they could get punitive damages, they didn't realize a particular remedy or cause of action wasn't permitted under the statute they filed under. And it gave us a lot of opportunity to dispose of cases pretty quickly. And so at the end of the day, it's not necessarily that this was such a bad thing for either side or a good thing for either side. That rebalancing probably benefits both sides of the aisle. And so we think maybe that's why we didn't see as much pushback as we, maybe would have expected. So let's talk about passage. Like Dan said before, this law had a pretty fair amount of bipartisan support. Again, 57 to 38 in the House, 30 to 1 in the Senate. Ultimately passes. A decent balance of Democrats and Republicans, favoring Republicans a little bit more in the House. In the Senate, you had one lone nay, and that was a Republican. So it's sort of an interesting breakdown, but it shows that it was more bipartisan than perhaps you would have expected. Later on in the presentation, we'll have a helpful links section, and in there we've linked to the Ohio General Assembly's HB 352 page. It's actually I guess if you want to really go deep on this thing, it's a real treasure trove. It's got the summaries, it's got the bill text as it went through each house, as it went to the General Assembly. Each committee's got its minutes on there, and you can really get a feel for who is advocating and what the real advocation was. It's pretty interesting to go through and read it, specifically because if you're going to be making arguments about these laws and interpreting them later, it's not a bad idea to figure out why these things were introduced, what the legislature was intending, because inevitably there are gaps, and we'll talk about specifically the effective date a little bit later. To the effective date, there's been a real debate here as to what the effective date is. It says in the bill 90 days after signage, right? And technically that's April 12th, based on when it was actually passed. But the Ohio General Assembly's website says it's April 15th. Not sure why. That may change, but we don't think it will. Maybe April 12th is a Monday. Maybe nobody wants to deal with a new law coming out of a weekend. The 15th is a Thursday, and that's a lot more palatable for dealing with new laws. I'm not sure. But in any event, the Ohio General Assembly says 4/15. That's what we're going with right now, unless we hear anything else. And I also thought, just as an interesting anecdote, the other law signed on the same day, which got some press as well, was HB 295, which regulates the most vile and vexing urban blight, electric scooters. So that was the other law passed alongside this. I don't think it'll have the same impact, but our streets will be safe from, street toughs on roving on electric bikes and scooters. So big day for Ohio law on the 12th. I'm going to kick it over to Dan. Actually, here's a close-up shot of Mike DeWine signing HB 352. I think is notable. You can see it really went at it. And Dan is currently on mute, which in today's generation should not be happening. We've been on Zooms for 9 months, but somebody has to do it.
I was just talking. I was getting into the electric scooter discussion, and I got a little overly excited.
We'll do a separate electric scooter webinar. I think it's equally as important.
I'm signing up for that. I'm going to be the first one. But certainly the headliner here in HB 352 was the change in statute of limitations. Everybody understands what a statute of limitations is. You may not know what an administrative exhaustion requirement is, but the concept of how long do I have to file a claim before it goes away. That was what certainly drew the most public attention to this new law. We shortened from, as you can see, 6 years to 2 years. And, I can tell you that, around the country, working in various states and seeing their statutes. You see 2 years, you see 3 years, sometimes maybe 4 years. 6 years was just way out of the norm, and certainly the longest statute of limitations in the country. So 2 years is certainly brings us much more into the mainstream among the states. Certainly provides more than adequate time for someone to realize they have a claim and to assert it if they believe they've been discriminated against. But the issues raised by 6 years are obvious. I mean, you could see the cynical response to the statute is that all employers are looking to reduce the statute of limitations, so it's harder and harder for people to bring claims of discrimination. I think the answer to that is 2 years is still more than adequate time to assert a cause of action, and that we'll see in a moment that could be extended beyond the 2 years. But the reality is, if you think about an employer, think about your own situation. What's your turnover rate? Is it 20%? We've got clients that see turnover in excess of 100%. Is your business seasonal? Do you hire a lot of students? If you think about a business with a 20% turnover rate, after 5 years, if you were to go and try to defend a lawsuit filed about an employment decision made 5 years ago, you're not going to have any witnesses left. Your ability you may and you can retain the records, but oftentimes you're going to be in a situation where the witnesses to the incidents have gone. They're 3 jobs down the road for them. The decision makers have gone, or they've moved on to other things, and the ability of an employer to offer a defense to a decision made 4 or 5 years ago was really difficult and prejudicial. And as Chaz mentioned, this wasn't a huge give for the plaintiff's bar. It's not a big win for employers and defense attorneys, in that we're not seeing a lot of lawsuits filed 5 years after someone loses a job or a claim arises. The reality is that employment litigation, they often tend to be emotional cases. They're people losing a job is an emotional event for a plaintiff, and oftentimes the litigation results from that emotion, even when there is no real cause to believe that discrimination has taken place. Regardless, as people move on and they find a new job, or maybe another, they move on in their life, the number of people choosing to file a lawsuit after 2 or 3 years after an event has transpired is pretty limited, and not something that we saw very often. So this is an important change, but not one that I think is going to dramatically reduce the total number of claims that we see. The other big impact that this has is on records retention policies. As we draft and advise employers about their records retention policies, we always have to remind them: are you considering Ohio's statute of limitations? You might think you might have a policy that's driven nationally by Title VII timelines, where you think after my federal claims have expired, there's no potential for litigation. But in Ohio, we have to be mindful, or at least until April, of the 6-year statute of limitations. So there's going to be an opportunity to revisit some of those records retention policies and make a decision about what makes sense transitioning from a world where our policies were written with a 6-year statute of limitations in mind to this new environment, and what makes sense both from a legal standpoint and a practical standpoint in terms of what documents are retained and for how long. Certainly in that kind of process, that's not something you want to do off the cuff. A change in your records retention policy should be something deliberate and thoughtful. And certainly, as we'll talk a little bit as we transition from one statutory scheme to another, making sure that we don't lose things that we may still need for matters that could be filed. Another significant, important change is the, I guess, almost elimination of supervisor, personal liability. Oftentimes we'll see a supervisor or manager named as an individual defendant in an employment discrimination action, and just as employment litigation is personal and emotional for a plaintiff who maybe has lost a job, I can certainly attest, as can many of you, that being personally named in a lawsuit alleging workplace discrimination or harassment is a very personal and oftentimes emotional process. And oftentimes we would see individual managers named not for any real purpose. The employer was named as the defendant, and the employer would satisfy any judgment or settlement that was reached. The plaintiff's lawyer oftentimes would name an individual manager or supervisor that was a resident of the state of Ohio, because that would prevent oftentimes an out-of-state employer who's doing business in Ohio from removing that case from state court to federal court. Not going to go into too much into the civil procedure here this afternoon, but by limiting that tool, as you can see, to claims where the individual manager is actually the employer, maybe the owner of the business, or it involves a claim of retaliation, we will see less ability for plaintiffs' lawyers to strategically name those individual supervisors as defendants in the action. That'll be an emotional relief for some of them, but also strategically, it's another tool for a defense lawyer to potentially get a case out of state court and into federal court, which most of the time we think is a better forum for us.
And I would add, Dan, that if you're in HR, this has got to be a huge sigh of relief as well. Because, absolutely. I've seen HR individuals get drug into these cases named as supervisors because oftentimes, there is a blurred line or there's confusion about hiring, discipline, and discharge, right? Somebody may key in on an HR individual and say, well, you were a manager or supervisor, therefore an employer under the statute, and drag in HR people whose job literally is to do, the administrative side of that and counseling the organization through it. And they get unnecessarily drug into it. Especially in my time in-house, having to counsel individual managers and supervisors who've been personally named to think that someone's just called them a racist or a sexual harasser, publicly, where other people can see it, their friends, their family, their fellow parishioners at the church. And, am I going to lose my house? Am I going to lose my job? All that stuff was just an unnecessary emotional toll on folks. And I'm glad to see it go.
Yeah, the explanation of, they're just doing this, because of the impact it has on federal versus state subject matter jurisdiction is not a satisfying explanation for the person who's looking at their name, in the newspaper or online or wherever as someone who acting out of discriminatory animus.
Right. Yeah. Not a welcome sight. Let's move on to administrative exhaustion, which sounds more complicated than it actually is. It's a fancy lawyer term for you got to file with the OCRC before you file a lawsuit. As the law is currently until April 15th, you could file an OCRC charge and file a lawsuit simultaneously, one after the other, or whatever you wanted to do. It was wildly impractical for employers. Oftentimes you'd be litigating in two forums sort of at the same time, and it really made for extra burden, and it both for the state, quite frankly, and for employers. And in the meantime, you could also be just waylaid with cases, right? Because somebody wouldn't have to file an OCRC charge. Wham, you just get hit with a lawsuit. And you may not have had that notice like you would in the federal forum of seeing the case before it's actually going to get filed. Again, opportunity to potentially settle that case or, go through ADR or whatever it is. You just got hit with it. It landed on your doorstep. And that surprise is pretty frequent. I get employers call all the time. We got smacked with a lawsuit. Something happened 2 years ago and we had no idea this was coming. And so that, surprise element's going to be taken out. So let's talk a little bit about administrative exhaustion, how the heck we got here. How did we not have administrative exhaustion when both federal and some other places did? And it can only be described as a series of judicial and legislative whoopsie-doos, as usual. So originally, believe it or not, the original Ohio civil rights law did require administrative exhaustion. It was mandated originally. Then 1987 hits, the General Assembly amends a portion of the law. And really they did it to pull out this criminal element of the law. There was a misdemeanor element of it, and they tried to pull that out. The language, as is often the case, like Dan said, when you legislate by committee, was a little less than clear. And what the language said is, hey, it's not a misdemeanor per se, but actions under 4112, Ohio civil rights law, are subject to civil action. Well, you can imagine what happened then. Plaintiffs' attorneys immediately went after that and said, hey, this is a separate cause of action. We don't have to administrative exhaust because this is what the legislature says. So the year is 1991. Enter the Ohio Supreme Court. It's 1991. While the whole country's distracted watching, I don't know, Terminator 2 Judgment Day or whatever, the Ohio Supreme Court does in fact interpret that provision to say, yeah, you have a separate cause of action. And that sort of set the whole thing off. That's what we've been subject to this two-track form of litigation with Ohio civil rights cases. And now HB 352, the Uniformity Act, is going to take us back to where the law originally was supposed to be. So now you can't just go file a lawsuit in Ohio. If you're talking about workplace discrimination, you're going to have to go file with the OCRC first, the Ohio Civil Rights Commission. Then, only after you file it, are you able to go file a lawsuit in these limited circumstances. And so just like the federal framework, the OCRC is going to get a copy of the charge. It's going to, and we'll go through the process a bit. But at the end, the only way you can file a claim is the OCRC issues a right to sue letter, much like the federal court, the federal EEOC would. The individual can also request it. The individual could go in and say to the OCRC, I'm just filing this to perfect my rights. I just want to file a lawsuit. Just give me my right to sue letter. Or the OCRC potentially finds probable cause and the complainant elects to pursue the claim in court. And if you've not been through this process, let's do just a little bit of a look at the OCRC process. So very much mirrors the federal side of things. Charging party files the charge of discrimination. You're going to get notice of it. It's going to go to, whoever it goes to, who's on record. And you're going to get a notice saying, hey, this has been filed against you. Then the OCRC is going to start its confidential investigation process. And that process is going to be, a lot of times involves requests for information, position statements, things like that, exactly the same way you have been dealing with things on the federal side. But this is really for you guys who may not have gone through this before. That's what it's going to look like. It takes a long time. The OCRC has about a year to go through and make its investigation and final determination. And then now what it looks like is once they go through that, again, they're either going to find probable cause, hey, we think something happened here, charging party, or the OCRC can bring suit. They'll find no probable cause, meaning, look, we went through this. We're just not real sure anything happened here. There's not enough. We're going to say no probable cause. We're going to issue a right to sue letter. And then finally, again, the charging party can't, and frequently you see on the federal side, they do just simply file a charge to say, I want to bring a federal suit. I don't want to go through the OCRC process. So we're going to see how long these mechanisms take. I think that's the big question mark. I'm assuming the OCRC is going to get an influx of claims. If you look at the docket reports every day, there are multiple Ohio civil rights related cases being filed. The question is going to be is how long it's going to take to get to the OCRC process. Even if you request the right to sue letter, they may take the full statutory amount to actually issue that. Whether this backlogs and makes the cases harder and longer to actually get through the OCRC process, all those things remain to be seen. But certainly at this point, we have a good indication that it's probably going to streamline the process and reduce some of that surprise element. Flip my slide here. So if we look at the process now versus federal law, like Dan said earlier, it's not quite parity, but it's close. We're getting closer to what the federal looks like. So you can see this chart here. Get through here. There we go. You can see this chart here is just a quick rundown of what it's gonna look like. Federal side, depending on whether you're at a work share agreement, 180 or 300 days to file your charge. Ohio's 2 years. So even Ohio went from 6 to 2, which kind of seems like a big jump, but you could see people arguing that, it's taking people's ability to file a claim. It's really not that much different from the federal. As a matter of fact, it's actually more generous than the federal. So I'd argue that any of the arguments relative to the 6 to the 2 jump kind of ring hollow, given the fact that this is the way the federal system is treating it for years. From a lawsuit perspective, little bit different here. Lawsuit in the federal side, look, you get your right to sue letter, you got 90 days to file it. In Ohio, the interesting idiosyncrasy with this law is that you're going to have a tolled statute of limitations. So I've got 2 years to file my claim with the OCRC. Then it's tolled. Statute of limitations is no longer running. Whatever's left in the tank on the other side of that, that's how long you have to file your claim. We think that, very well could be subject to later interpretation and things like that. But right now, that's what it looks like. You file your claim. You got 30 days left in the statute of limitations. Process takes a year to get through the OCRC. You got 30 days after you get your right to sue letter to file your claim. And there'll be a lot of back and forth here. There'll be a lot of confusion about dates. If you work on the federal side, really important when you get these OCRC charges or on the EEOC charges, and the same in Ohio, really important about when those dates hit. When did the claim accrue versus when they filed it? Did they get in the 90 days? You get into mailbox rule. You get into all this other stuff that takes place. But that is going to be some case law that'll develop in Ohio as well. And so if you're internal right now and you're in HR or you're in-house counsel, you want to be looking at your intake processes for this new OCRC framework, right? You're going to be paying a lot of attention to, when the claim accrued based on the information in the charge, when was it filed, and specifically how much of the statute of limitations was left once they got the right to sue letter. When did the OCRC process actually terminate? Things like that are going to be really important from the intake perspective when you're assessing those claims initially when they come in. So you put that stuff on your checklist or update your checklist or whatever it is that you're going to do.
And Chaz, I would think also keeping in mind the potential that the 2-year statute of limitations, really with the addition of an OCRC process, could push that to 3 years if the Absolutely. OCRC runs for a full year. When we were talking earlier about I'm going to revise my records retention policy. Keep in mind it says 2 years, but you could end up having a lawsuit filed, essentially 3 years afterwards, and that would still be timely. So again,
and not to mention the fact
make step changes.
Yeah, and also what happens with the OCRC. I mean, if they get just an atomic bomb's worth of claims all of a sudden filed, it's going to be tough for them to get through in a year. Again, they're understaffed. They're they're working with a budget deficit. We may see things push closer to that year mark if, potentially not over. And then what happens in that circumstance? Again, that's all unclear. I'm sure courts will clear that up, and I'm sure it'll be crystal clear after that.
Yeah, good luck with that. Maybe certainly important, but maybe not one of the more dramatic elements of the new law is codifying the Farragher-Ellerith affirmative defense. This is for those of us who again, go back to the 90s here on federal Title VII sexual harassment statutes. It's under Title VII. It is a defense in a harassment case. The Farragher-Ellerith were the two United States Supreme Court cases that developed an affirmative defense. It was developed through the case law as opposed to in the statute. Ohio had, for its discrimination case claims, if you brought a sex discrimination case alleging sexual harassment in Ohio under Revised Code 4112, the court is going to look to federal Title VII authorities for guidance, and that would include this affirmative defense, which has been around for a long time, and permits an employer to avoid liability in a harassment case if it had a policy in place to prohibit harassment and gave employees an avenue to complain about harassment and take remedial action. And an employee that fails to take advantage of the complaint procedure and would lose his or her claim. So that body of case law was developed under Title VII, has been followed by Ohio courts applying Ohio law, and this this act codifies that and makes it a formal part of Ohio statutory law as opposed to just our case law. To the extent there's a takeaway from this, I think it's if you don't have a sexual harassment policy, if you don't have a complaint procedure, if you don't train your HR team or your in-house team on how to handle reports of investigations, this is a reminder that there is a defense available, and it's critical employer take proactive steps to take advantage of that defense in the event you face a complaint of harassment. Age discrimination cleanup. As Chaz alluded to at the outset, the age statutes in Ohio were a mess. There were numerous different claims that could be brought alleging age discrimination. The statute of limitations for those claims varied dramatically from 180 days to 6 years. And depending on which claim you asserted, that impacted the remedies that were available to you. There were some good defenses available to employers in the event that an employee brought an OCRC charge before they brought an action in court. And those were surprising and difficult. I think this is one of the changes of the law that's probably the most helpful to employees, only in that it makes it far easier to understand that an age claim in Ohio is now an age discrimination claim is now no different than a race discrimination or sex discrimination claim. The process is going to be uniform, and a 2-year limitation period will apply to all of those. So that was an area where again it was convoluted, and kind of growing up with these statutes as younger lawyers learning the law in Ohio. There were kind of some head-scratching moments of, well, how can it be that way? But it did result in a lot of kind of technical victories for employers able to defeat claims or exclude certain remedies because employees didn't know how or didn't really understand the statute. And this makes it certainly more uniform, again, providing a little more clarity and certainty to both employers and employees. Another issue, caps on damages. Ohio, tort reform has been around for a while. Limits, put limits on compensatory damages, and there were arguments made by employers that those limits should be applied to Ohio's to claims arising under 4112. Employers were, predominantly successful in those arguments, and those have been now codified as a part of the statute. And essentially, you can see here what that means. The economic damages are what they are, whatever the employee lost in terms of lost wages and benefits as a result of the act of discrimination they can recover. But there are limits placed on the non-economic damages and the punitive damages, which are kind of the harder to predict elements, that kind of the pain and suffering, the mental anguish claims that are harder to value. And if they're left, if there's no cap on those damages, you can make an argument that the damages in an employment discrimination claim were limitless, and so this scheme and this act codifies some limits on those damages, both in terms of the pain and suffering type damages, as well as punitive damages, which are damages designed to punish an employer who has acted in violation of the statute, so to deter future violations. So this is certainly a cleanup and something that provides, again, further clarity and certainty as to both sides as to what the scope of potential damages are in an Ohio employment discrimination case.
Yeah, and I think one of the outstanding issues with respect to that is whether the caps apply to judicially modified damages or jury awards. And, this case law came out from a couple of years ago from the Lurie case. I don't know if Dan mentioned that rather, but that was the $43 million sort of runaway jury verdict in an age discrimination case. And we got a lot of judicial attention then. And so the law's been this way, and this codification is just, in the event there's some far-flung appellate court that for whatever reason, or a trial court isn't following it, it's clear now in the law. But I think that's really the only outstanding issue is what is the cap going to be based off of? So I guess we'll wait for more judicial interpretation of that.
And Chaz, before we switch to retroactivity here, if I could just jump in, I've been following the Q&A. One, glad to see so many people attending, which is great. And we've also got a lot of questions. And I could tell we're not going to be able to hit all of the questions. And so if you have questions, please submit them now to the Q&A on any of the things we've covered. We will, if we don't get to your question as a part of the webinar, we will be able to follow up with you afterwards, but only if you get it into the Q&A. So if you've got something you're thinking about, maybe you can put that in now while Chaz drones on about retroactivity.
Okay, wow. How dare you? Retroactivity. This is the big question about the Uniformity Act. Does it apply to retroactive claims? If you look here, this is the quintessential example. If I have a claim that accrued, so I was terminated and I believe that it was based on discrimination 4 years ago. I have not filed a claim, haven't filed an OCRC charge, but as of April 15th, do I still have a cause of action, or does the 2-year statute of limitations essentially extinguish that cause of action? The answer is we don't actually know. We have some ideas, and we'll be happy to give those to you, but we don't actually know because HB 352, the Uniformity Act, was unclear as to the specific provision. They had the ability legislatively to say it's retroactive. They didn't do that. So that's going to leave it again up to interpretation. A couple of takeaways here. Generally speaking, statutes in Ohio are presumed prospective rather than retrospective. So that's one thing. But there is case law developed in other areas that would suggest that you can shorten a statute of limitation, taking away a substantive right or a vested right because that person hasn't filed a claim yet. There's also the retroactivity clause in the Constitution, which says that you can't take away a vested right, can't take away an accrued right. We're not sure how this is going to go, but we see the potential for a couple different ways for it to go. One way here is the courts or potentially the legislature later on says it's not retroactive. If you have an accrued claim in the past, and as long as you bring it, within the statute of limitations in effect at the time, that claim is still viable. Another way it could go is that HB 352, this new law, could apply, but only with respect to administrative exhaustion. So I have a claim that's 4 years old. I go to file it after April 15th. Maybe I don't have the right to go directly to court. I still have to file that claim with the OCRC. That's sort of the middle ground. And then the third potential is that it is, in fact, absolutely retroactive, and it would apply to accrued but unfiled actions. And so it's kind of the way we see the world right now. Again, we are going to need to, of course, to decide this, and it could take years for it to make its way through the system. But as of right now, we see arguments on every side. Here's the good news at the end of the day. You have all those arguments right now. If one of these claims gets filed and it is outside that 2-year statute of limitations and it is after April 15th, 2021, heck yeah, you're making that argument. I'm going to make that argument all day until a court tells me I can't make that argument. We've done some of the research. We have the case law. Happy to help out in that scenario. But I think, look, you got the arguments now. Make them. Dan, what do you think about that?
I think that's what we know today. We'll have to see. But I think it's a transition period. At some point we'll be down the road and there won't be the uncertainty. So we got a temporary period of kind of seeing what what comes and how the case law works out. But pretty soon we'll be under where all the claims are arising under the new statute, and at least going forward. I think we treat any claim that going forward is covered by the new act, and we'll have lingering concerns about what may still be out there and potentially actionable, which I think is all the more reason to be cautious and deliberate in how we, if you're going to take a change in how your intake process or how you're evaluating charges, cases, how you're retaining documents. It's not going to be a flip a switch and overnight that things are going to be done. There's going to need to be some thought about how do you transition from where we are today to where we're going to be shortly.
Yeah. So jumping to, I did see one interesting Q&A that I would bring up for Dan and I's short discussion, and that's with respect to supervisor liability. One of the caveats, the carve-outs there is this aiding and abetting concept. And somebody made a fairly astute comment that, is that going to be wildly exploited? And I think, yeah, I think that potentially could become the exception that swallows the rule. I think you will see these claims continue to get brought with aiding and abetting in them. And there's some case law on point already. There is an aiding and abetting portion of many of the existing laws. Now, whether that's directly applicable to this new law, unclear. Most likely courts will use that as a guidestone. But I do think that's a potential here for a real issue, is that we could be litigating heavily for the next year or so what aiding and abetting means under the current law. There's no great answer to that right now, but I think that is definitely an area that's going to be subject to heavy debate in the next couple of years.
And I think, to the extent that a plaintiff's lawyer is adding a supervisor or manager as an individual defendant for strategic reasons related, maybe to jurisdiction, as opposed to some true desire to have that person named as a defendant, they can certainly make those allegations and allege aiding and abetting. The individual will be named as a defendant, and that will have the impact they desire. So I think that's a tactic that we'll see utilized.
Yeah, absolutely.
Pretty quickly. Chaz, I kind of read like 3 or 4 questions, and this is kind of a combined one. But I think the gist of it is, never really done much with the OCRC because we've had cases go straight to lawsuits, and when we've gotten charges, we've kind of ignored them. What's been your experience with the OCRC actually resolving charges through maybe through a mediation process? Is that effective? Is that a useful tool for an employer to consider, or is this just another hoop we're going to have to jump through?
So I've had a fair amount of experience with the OCRC. I mean, probably like you get more dual file that are being handled by the EEOC than you do, and the other ones are just straight to court. But in my experience, the mediation mechanism is as good as the mediator you get. And if you get the right mediator and the parties come at it like, hey, we're, probably going to be a little pain on each side of this thing, and you're thinking creatively about, it doesn't have to just be money, loading up some non-monetary incentives. Yeah, I think you have the same opportunity you would any other place to potentially settle a case. But again, I think it's going to be pretty case specific. If you get a great mediator, you have a chance someone that's going to talk to both sides pretty earnestly and pretty, have real talk. Yeah, I think you got a decent chance. I think you're probably better at the EEOC level or in a court mediation program, but I don't think it's a illusory mechanism for settlement of cases. And frequently you can go to the EEOC or the OCRC as well and start to really talk about the settlement process and try to get them to put a little pressure on somebody to think a little bit more clearly about it and think a little bit more, real about what exactly it is they want out of this thing. So it's a long-winded answer of saying, yeah, I think you got a decent shot at it.
And we've had, a number of cases over the years where the OCRC actually finds probable cause and elects to initiate an enforcement action of their own, where the commission actually brings an action to enforce the statute itself, as opposed to having the employee file a private cause of action in court. But the reality is that, as Chaz mentioned, the OCRC's resources are very limited. Their ability to bring enforcement actions is a little bit better than zero. And with a flood of new charges to investigate, there's going to be, even if there are a flood of more charges drawing probable cause findings, that doesn't mean we're going to see, many more enforcement actions than they already have. So the process, the ultimate decision may not matter that much, whether the commission finds probable cause or not. Except for one exception, and I'd love to get some data on this someday. But I mean, certainly, as I mentioned earlier, for many, an employee who is terminated, their options, if they are angry, if they are emotional, upset, as many are, losing a job, does have emotion involved in it. There aren't a lot of causes of action in an at-will state like Ohio that an employee can go to, and the discrimination statutes do provide one such avenue. And sometimes an employee in an emotional time wants to do something, to assert something, to do something adverse to their employer, to kind of maybe not solve all their problems, but kind of get that out, and maybe that helps them move on to what's next. It's a lot easier and cheaper to have them get through that process with an administrative charge as opposed to a lawsuit. Costs are far less, and sometimes simply filing the charge, letting that process take place, go forward. By the time the agency resolves the charge, maybe that employee has found a new job, they've moved on, they've got a better situation, and litigation in court which would involve discovery and depositions and both time and money and energy is not as attractive. Whereas when they were first coming off this decision, this termination decision, and they were emotional and angry, maybe they're a little better spot, and maybe having gone through the charge process first, it reduces the likelihood that employee is going to choose, their former employee is going to choose to file a lawsuit. But that'll be interesting if the commission starts putting out. We get reliable data. We could even maybe try to evaluate that. That'll be interesting.
Yeah, and I think dovetailing off of that, Dan, I mean, sometimes just taking the temperature down and giving an employee a bit of a cathartic release can be enough. I mean, the best mediators in the world that, can mediate in a way that allows an employee to get in front of their former employer and say, I mean, for lack of a better word, hey, you screwed me, man, and I'm mad about it. And sometimes just getting across the table, seeing another human. There's a lot of times why I advocate sending client reps with me to mediations and things like that to allow them to look at somebody and talk to them. And maybe even say, look, this is a bad situation. We're sorry it ended this way, but it wasn't because of X, Y, and Z. And sometimes that can take a little bit of the temperature down. And then likewise, a lot of times, you have plaintiff's attorneys who are evaluating these cases solely off of what their clients are saying. And the process of going through the OCRC will provide additional information and education. And so hopefully that'll at least have some effect of taking some of the more frivolous claims down when plaintiff's attorneys get a lot more information from the OCRC process and potentially reevaluate claims in a way that they wouldn't if they were just getting information directly from a heated up litigant who's just looking to take their pound of flesh out. So moving on, here's some helpful links, guys. Just take a peek at these. These are some things that we use to put the presentation together. Certainly the HB 352 summary page of the Ohio General Assembly, fantastic resource. Again, you could nerd out, go down that rabbit hole, read all the committee notes I did. It's pretty interesting. Second, I would be remiss if I didn't shamelessly self-promote our e-alert on the same subject, which is, of course, right there. Take a look at it. It'll go into a little bit of a deep dive. And then last but not least, for those of you, I saw a couple of Q&A questions about the OCRC process, and someone asked what it stands for, the Ohio Civil Rights Commission. If you're curious about that process, if you haven't gotten a charge, you might, right? Especially in the next year, you might get one. That's an interesting resource that'll talk about what the OCRC does and does not do, how they handle cases and things like that. That's a nice starting point to the extent you get one of those. Before you lawyer up, you may want to go look at that resource and just get familiar with the process. Here's a picture of Dan and I's mugs, along with our contact information. If you'd like to call us or email us, rather, it's right there. Also, our LinkedIn profiles. You can follow both of us if you want to see us posting, new developments and articles and things like that. Always happy to interact in that arena as well. So, with that, if we didn't get to your questions, we're really sorry. We're verbose. And we will follow up with you afterwards and help you out with that. A lot of the questions, too, were hard to do on the fly while we were doing the webinar. We'll give you a little bit more of a thoughtful response once we had time to dissect it a little bit. But feel free to reach out, contact us if you have any questions. The slides will be shared afterwards that we sent out via email, so you will have copies of them, along with Dan and I's pictures for later use or anything if you want to know what we look like. You can't remember us. But other than that, with that, Dan, I don't have anything else. We're at the top of the hour. Anything else before we go?
No, it was fun. Thanks.
All right, everybody. Thank everyone for joining. We're so happy. Appreciate your time. I know everybody's busy. Hopefully you got through lunch and you got some lunch and learn here. And we'll see you next time.
Thanks.